Hello and welcome. Today we're diving into a really crucial part of India's new criminal code, the BNSS 2023. We're talking about the complaint proceeding. Now this might sound technical, but it's an incredibly powerful tool that lets any citizen, like you, go directly to the courts to seek justice, totally bypassing the police. So let's get right into how it all works.
Okay, so when a crime happens, what's the first thing most people think of? It's almost always path one. You go to the police, you file an FIR. It's the route we all know. But what if I told you there's another way? Path two, filing a complaint directly with a magistrate, is this powerful alternative that's built right into our legal system. It completely shifts the starting line from the police station to the courthouse, and it's an option that every citizen really should know about. To make this super clear, here's our roadmap. We're going to walk through this whole journey in 5 key stages. We'll start by understanding this alternative path, then look at how to make a formal complaint, see how the magistrate examines it, what goes into their critical decision, and finally, what happens after that decision is made.
All right, let's kick things off with Section 1, another path to justice. At its core, this is all about knowing the options the system is actually designed to give you.
You see, the fundamental idea here is simple, but it's also incredibly powerful. If you believe an offense has been committed, you have the legal right to skip the police station altogether and take your case directly to a court, specifically to a magistrate. And let me be clear, this isn't some kind of loophole or workaround. It's a formally established procedure.
So, where does this power come from? Well, the legal foundation for this entire process is right here. Section 223 of the Bharatiya Nagarik Suraksha Sanhita, the BNSS. This is the specific rule that gives you, the citizen, the power to kick off criminal proceedings directly in front of a magistrate.
Which brings us to Section 2, making a formal complaint. Okay, so knowing you can file a complaint is the first step, but the next, super important step is knowing what the law actually considers a valid complaint.
You know, what's amazing is just how simple the legal definition is. Under the BNS, a complaint is just an allegation you make to a magistrate. You can even do it orally or in writing. The key, the absolutely crucial part, is your intent. You're not just reporting something for their information. You are specifically asking the court to take legal action. That's the difference.
So once you've made that complaint, something very important happens legally. The moment the magistrate officially starts considering your complaint and applying their legal judgment to it, well, that moment is called taking cognizance. Think of it like turning the key in the ignition of the judicial engine. The court is now officially aware and is acting on your complaint.
So, the magistrate has taken cognizance. That brings us to Section 3, the magistrate's examination. Because once that happens, the law is very, very clear about the first, absolutely mandatory step the magistrate has to take.
And listen, this is not a casual conversation. Under Section 223, the magistrate has a mandatory duty to examine you, the complainant, under oath. And the same thing goes for any witnesses you happen to bring along. It's a formal, required step designed to get the initial facts of the case onto the official record, right from the very start.
Now, of course, like with most rules, there are a few specific exceptions. This whole examination step can actually be skipped if the complaint is a written one from a public servant who's acting in their official capacity, or if the complaint is being made by a court itself. And finally, if another magistrate already did the examination and then transferred the case over, well, it doesn't need to be done twice.
All right, now for Section 4. This is maybe the most crucial moment in the entire process, a critical decision. After that examination, the magistrate arrives at a major fork in the road and has to make a choice.
The whole point of that initial examination, all that sworn testimony, it all boils down to answering one central question. Is there enough here to actually proceed with a criminal case? Does this complaint have real merit, or is it basically baseless?
And that leads to 2 main outcomes. If the magistrate thinks there are sufficient grounds, the case moves forward. That's called issuing process, which happens under Section 227. On the flip side, if there are no sufficient grounds, if the whole thing seems flimsy or lacks evidence, the magistrate will dismiss the complaint under Section 226, and that effectively stops the case right in its tracks. But life isn't always black and white, is it? What happens in that gray area? What if, after the initial examination, the magistrate isn't totally convinced either way? Well, the law actually has a third option for exactly these kinds of situations. And this is where Section 225 is so important. It lets the magistrate hit pause on the decision if they need more information.
They can either conduct a personal inquiry themselves, or, and this is a big one, they can order an investigation to be done by the police or another expert. It gives the court the tools to dig a little deeper before making that final call.
And that brings us to our final section. What happens after this critical decision is finally made? Let's take a look at the consequences of each of those paths. So, if the decision is to move forward, the court issues process. What does that actually mean in simple terms? It means the court is now officially notifying the person you accused. They're going to be sent a summons, maybe even a warrant, which legally forces them to show up in court and answer to the allegations in your complaint. The case is now officially on.
But what if your complaint gets dismissed? This is a really crucial point for fairness. A magistrate can't just toss your case out for no reason. The law, specifically Section 226, says they must record their reasons for the dismissal in writing. This creates a transparent record and keeps the whole process accountable.
So does a dismissal mean it's the end of the road? Not necessarily. You still have legal remedies. First, you can file for a revision in a higher court, like the Court of Session or the High Court. You're basically asking them to review the magistrate's decision. Second, in some situations, you might be able to file a second complaint, though you'd usually need to bring some new facts or fresh evidence to the table.
Okay, so we've walked through this whole process, from start to finish. Let's just step back for a second and ask the most important question. Why does any of this really matter for you as a citizen? So let's just recap the big takeaways here. First, remember you can start a criminal case directly with a judge. Second, the process always starts formally, under oath. Third, that first decision by the magistrate acts as a critical filter for the whole system. And finally, even if your complaint is dismissed, it's not always the final word. You have ways to challenge it. Honestly, just understanding this process is a form of empowerment.
And that leaves us with one final big picture question to think about. This whole procedure exists as a parallel track to the usual police investigation. So, by giving everyday citizens this direct path to a judge, how is the law trying to balance the power and roles of the police and the judiciary in the search for justice? It's a fundamental question about how our entire justice system is designed. Thanks so much for joining us for this explainer.